Hello nears and dears, welcome to Law Friends. Dears, today we will learn about open court. What is open court? And we will learn that why the open court system is necessary for the society and the judiciary, and the benefits of open court. And we will also learn is there necessary legislation for this system open court, and we also touch to the history. And we will also learn that how to reach open justice. Lord Heward says, justice must not only be done, but must also be seen to be done. Now let's come to the open court. What is open court? An open court is one where the general public possesses the right to witness the court's proceedings, and anyone interested in observing these proceedings must be granted the opportunity to do so. So access to the general proceedings is the open court. So in these days in Pakistan it is necessary. There is open court, but there is no any live streaming system, and there is also in camera and in chamber courts on special matters regarding the state or regarding the special information about the government or about the state. So let's come that why the open court system is necessary. The openness and public witnessing of court proceedings build public confidence. So it builds public confidence. The judiciary cannot exist without the trust and confidence of the people. So openness is the soul of justice. If there is justice, then the country must adopt the open court system and live streaming system. Mr. Hegel, in his book Philosophy of Right, he asserted that judicial proceedings must be public, as the aim of the court is justice, and justice belongs to all. So open justice in open court is a wholesome check upon judicial behavior. So this is the checks and balance on judiciary system, that open justice and open court is completely and wholesome check upon judicial behavior, and it is proceedings. And regarding this, there is a question that how to reach open justice system in Pakistan. So if we implement the Article 19 of the Islamic Republic of Pakistan, and that is the right to information. So the implementation of the right to information, that is Article number 19, is the solution, and they couple with the current technology of live streaming is also the solution. So there are two solutions regarding this open court system and open justice system. That is implementation of Article 19, right to information, and second one is live streaming is the solution. If the judiciary of Pakistan do start the live streaming of the proceedings in the courts, then there is a public confidence, and they will see and they will hear the proceedings from the homes. So dears, if we come in opposite to this idea of open court, that is in camera, it means in chamber or in camera proceeding. So the in chamber and in camera proceeding are not accessible for the general public. So in opposite to in camera and in chamber court proceeding, there is open court, which we have discussed. And now come to the benefits of open court and live streaming. Live streaming is the soul of open court. If there is a live streaming of every proceeding in the court, then I think it is the soul of the justice that it must be seen in the eyes of the public. So if we come to the benefits, first benefit, it will create confidence in public for judiciary. Second one is that if we do live streaming of the proceedings, we can say that it is the implementation of Article 10A of the Islamic Republic of Pakistan, that is right to fair trial. The third one benefit, that open court will enhance the delivery of justice. And the fourth one, that is open public access to the proceedings and live streaming would completely eradicate the issues of misreporting, underreporting and errors. So these issues of reporting can be eradicated with live streaming of the proceedings of judiciary. Now let's come to the question whether there is a need any specific legislation regarding live streaming. So the answer of this question is no. There is no necessity for separate legislation concerning live streaming of the judiciary proceedings. According to Article 187, Clause 1 of the Constitution of Islamic Republic of Pakistan, the Supreme Court of Pakistan possesses the authority to issue directions and orders or decrees necessary for ensuring complete justice. So there is already the provision regarding the open court, and high courts also possess jurisdiction to frame adequate rules for live streaming. So the issue is in the courts. The Supreme Court and the High Courts have the complete authority to implement the orders and rules and make their own rules regarding the live streaming. In this technology system, if you have to make confidence of the judiciary in the eyes of the public, then you must implement the live streaming and the technology developments in the court system. And last, we come to the history that when there was no open court system and the British government passed the laws regarding the in-camera court system. So let's come and see that what were the results of that draconian law. In 1919, the British government passed the Anarchical and Revolutionary Crimes Act 1919. This act provided for speedy trial of offences by a special court consisting of 3 high court judges, and this court could meet in camera, not open court, could meet in camera and could take into consideration evidence not otherwise admissible under the Evidence Act. No appeal was provided against the decision of the court. So in response, Mr. Muhammad Ali Jinnah resigned from the central legislature in protest, and Mr. Gandhi launched a movement of Satyagraha against the act and called for countrywide strikes. Although Mr. Gandhi started a peaceful and non-violent movement, the movement led to violent protests and disorders, and a number of people in Delhi and Ahmedabad were killed by police firing. The worst incident occurred in Jalwabwala on 13 April 1919. Under the orders of Army Commander Brigadier General Dyer, troops opened indiscriminate fire on a peaceful but large public meeting in Jalwabwala Bagh. 400 people died and 1,200 were wounded. In the result, Gandhi decided to call off Satyagraha because of the violence and the killings. So Gandhi did not want the violence and the killings of the people, so he called off Satyagraha movement. So yes, this is the historical incident that happened in 1919 because of draconian and because of in-camera laws. That in-camera court system was against the open court system. So this was the result of in-camera court system and proceedings. So to conclude, if the judiciary had to make its own confidence in the public, then it must implement the live streaming system and the Article 10A of the Constitution of Pakistan, and different modern technologies must be implemented in the proceedings, as the justice can be seen to be done in the judiciary system.